Today we're going to talk about claims and derivative actions. This is now the part of the module that talks about what do you do if you are in a minority position and you feel that the others are ganging up on you and that you're getting somehow mistreated in the context of a company. The shareholder has a few shares in a wider structure where there are lots of others that are going to either have the majority of shares or they're coordinating with each other in order to. Now, the two main ways in which people in a position of weakness can defend themselves is through either the derivative action or unfair prejudice. You need to keep in mind all the various rights that we've had of the directors, and then the possibility of compensation for the company when the directors have done something that causes loss, for them to be able to identify precisely what it is that you're complaining about. One of the things that we come across here is that there's no point complaining for a violation that's theoretical. People will complain about something that results in actual loss. Now, if the directors could have done a lot of things wrongly, or they could have forgotten to do things, or they could have made a variety of mistakes, but if those mistakes don't have an observable consequence on the company, and observable consequence probably means that somebody lost money somewhere, then there isn't much incentive to go after them. So we're not approaching the various tools that people have got to complain from a purely kind of vindictive point of view or a completely as a theoretical exercise. What do you do to chase after people who don't do their jobs properly? The courts and the whole system and the tools that we have available are available for somebody to use when actual damage has been done. Is the idea you can use these tools to repair that damage. The beginning perhaps of this discussion is the idea that the directors owe their duties to the company as a whole and not to individual shareholders. When the directors have done something wrong in violation, say for instance that they were not paying, have not exercised care and diligence in the transaction with third parties, either they're purchasing things from others and they're paying way too much, or they are divesting company resources, meaning they're selling some of the company's assets to other people and they're selling them at undervalue. In either case, the company is losing money. And the directors are doing this because either they're not competent or they don't care. Or even worse, it could be that there's something in it for themselves, there's an element of kind of double dealing, all of these things that we've seen as potential violations when we were talking about directors' duties. The harm of this comes and attaches back to the company. If I was a shareholder in a company that is mismanaged, I personally lose because the value of the share will eventually drop. Either this company is going to go insolvent because it is mismanaged, or it will develop a reputation as being a horrible company. Therefore, if I want to get out, I won't be able to sell my shares, possibly at the price that I bought them. This will be bad for me on a personal level as an individual shareholder, but the harm done to the company by identifiable misbehavior is harm that is done to the company, is harm done to everybody. So if I've identified a breach of duty, because the duty is owed to the company and not to me as an individual, then if I want to complain about it, I cannot really raise a case as an individual and say, these guys have sold the company van to that guy for next to nothing. Therefore, me as an individual shareholder, I'm going to lose out because the value of my share is going to drop if I want to sell my share to somebody. Therefore, I personally need to be compensated. This is taking somebody else's problem, the company's problem, and turning it into a personal problem, and then we don't actually have the link to go there. So what you have instead is this idea of a derivative claim, meaning what? I will complain about this violation, but I will complain about this violation not in my individual capacity, but as an agent of the company. I will be there to motivate the company through an action that I begin, but the action is on behalf of the company to protest the violation, to protest the harm that's been done to the company itself. Remember this, because this is going to be trouble, guys, later on when we talk about the unfair prejudice petitions, which are personal rights. So the stuff that we're doing next week, somebody individually is being harmed and are suing in their own capacity. This stuff is not somebody suing in their own capacity, it's somebody suing on behalf of the company. Any harm done by the directors breaching their duties is harm done to the company. And the company can safeguard its interests on the instigation of a particular shareholder, because it could be that the company lacks the decision-making capacity at board level to protest those problems. You might think, what's the reason of involving the shareholders for harm done to the company when there's supposed to be an independent board that does these things for the company? If the directors as a board are running the company, they're also responsible with protecting it. If a director has made a mistake or they have breached their duties, it's the job of the other directors to come after them. Well, yes, of course, it should be. However, it doesn't always work. It could be that the bad decisions are not bad decisions of individuals, but they are of the board in its totality. And we are usually talking about small corporations. There aren't loads of people. If we were talking about a large public listed corporation that has got a numerous board, a number of directors, some of whom have got an executive role and some have got an observation role, or they are non-executive directors, then in fact there's enough people to notice some misbehavior and then motivate the company to take action against that misbehavior. If it's a small private limited company and you get two people who are major shareholders and the directors, and you got another 2-3 people who are just simply shareholders at smaller percentages, the two people who are directors could be doing whatever they want, and they probably both know what they're doing. If they're both engaged in some type of violation, because it serves their personal interests, there's nobody else left at board level to pursue this in order to achieve a good outcome for the company. The company is this distinct entity, but if the board is malfunctioning or its interests have diverged from the interests of the company itself is left headless. There should be some capacity for individuals within the company who notice the misbehavior, who identify a board that is malfunctioning and not defending the interests of the company properly. There should be some capacity for these people on their own initiative to bring an on behalf of the company to defend those rights. So this is something that the courts kind of figured early on, and the idea of this derivative claim developed in the case law. And the first case in which we have it established in what became kind of more or less its modern forms, and harbottle, which is from 1843. The courts understood, as I said, the need to empower individual shareholders who have noticed wrongdoing to bring this as an action against the wrongdoers and do it on behalf of the company. But at the same time, the courts recognized that there's huge potential for disruption, because we have so far been thinking about a scenario where the board in fact is doing something wrong and somebody notices and wants to do something about it to defend a legitimate interest of the company. But that's not necessarily always the case. It could be that an individual shareholder just doesn't like the people on the board and would like to sue them in order to disrupt them, something that they're doing, because an individual does not approve of it, but there's nothing wrong with what they're doing. Say that business has a shop and they're thinking of expanding online, and one of the shareholders thinks this is a terrible idea, they don't think they will be able to compete online. It is not the shareholder's decision. So unless that person is in a majority position in the general meeting, or is also represented in the board and has power in the board, the fact that one individual disagrees with company strategy doesn't mean that there's anything wrong with company strategy. But if you've got a mechanism in place such as this derivative claim, and you allow people to sue on behalf of the company alleging wrongdoing, what is there to stop anybody who disagrees with the behavior of the board of bringing these actions on purely to harass them? While the courts have recognized that there is a need to have this to protect corporate interests, there's also needs to be some limitation as to how this, you cannot give it free to anybody to sue on behalf of the company. The case of foss and harbottle is the beginning of structuring limits within which the power to bring a derivative action can be exercised. The idea of limitation of this power comes by two key rules that are established in foss and harbottle. The one is the idea of a proper plaintiff, and the other one is the idea of internal management. So the idea of proper plaintiff rule says that the appropriate person to bring a claim for wrongs done to the company is the company itself. So this is what we've already seen coming from Salomon and the idea that the company has separate personality and separate legal standing. Cardinal idea is that since a company is incorporated and becomes a different person in the eyes of the law, harm done to a company can only be defended by the company itself in its individual capacity. But at the same time, you've also got the idea of internal management and majority rule, meaning that the board is there to manage, and you cannot have any other body usurping the powers of the management and doing the job of the directors for themselves. And you've also got the idea of majority rule, meaning that this is a kind of majoritarian institution in which the people who've got the majority of the shares decide what happens at general, and people who have majority of opinion at the board of directors also decide what the board of directors is doing. Foss and harbottle brings the two of these elements together and reiterates them so it avoids any confusion, and which then allows the court to put together some criteria to help us determine whether somebody should be allowed to initiate an action on behalf of the company. This company that was incorporated by Act of Parliament. Now there were 5 directors. The claimant was trying to bring an action against these directors alleging various fraudulent and illegal transactions. They were alleging that the property of the company was misapplied, it was wasted, directors were no longer capable of constituting a board, that they were engaged in various types of misbehavior, and effectively the company was run to the ground by people who were acting on personal interests and not the interests of the company. The court found that if you have a board available, then you will need to prove that the board has become non-functioning in any real sense and is not capable of defending the interests of the company itself before you are allowed, as an external to the board, to commence actions that are happening on behalf of the company. So what you have then is the idea that some fraud on a minority is being perpetrated, which allows an individual shareholder to bring an action representing the company themselves in order to defend this wrong. That was deemed to be too limiting, because if you reduce the criteria for allowing somebody to take over the powers of the company to bring an action to defend its interests to fraud, then you're only covering the nastiest of the things that can happen. You have an option for a derivative action, yes, but this is things that are intentionally wrong, that are intentionally designed to damage somebody in a minority position. And that person in a minority position needs to have no other opportunity to defend those rights unless they declare the board non-functioning and they take over the powers of the company in order to pursue these things. It doesn't cover mere incompetence, it will not cover negligence, it will not cover lack of interest in these things. Higher opportunity for things to be going wrong in a company, lack of attention or recklessness or negligence rather than intention. A lot of cases battled with the criteria of foss and harbottle, And you have like an extensive discussion in your textbooks about what happened after the case and how the courts tried to kind of interpret the criteria for bringing a derivative action, and how the courts were trying to open up the criteria a little bit, but there was always this debate as to whether the constraint as set in the original case should be retained and so on. The direction given in the case as to how to allow individuals to protest on behalf of the company was too limiting and not appropriate for the kind of circumstances that appear in the management of modern corporations. That's why the statute in section 260, you now have a statutory impression on what is supposed to happen when somebody wants to bring a derivative action. So now we no longer use the case law basis for bringing a derivative action, but we use section 260 of the Companies Act of 2006 as the power to enable the company to do something like this. The idea is that the court is given a broad role to exercise discretion as to whether it is in the best interests of the company to bring some litigation against the board of directors. What you have as the motivating idea is the idea that legitimate company interest has been violated by misbehavior at board level, and going through the trouble and the expense and the damaging reputational effects of litigation is actually going to lead to a positive outcome. So the court needs to be convinced that pursuing this wrong will leave the company, not the individual that's harmed. Somebody who feels that they've lost out, they will probably be in a better position if the action is brought. But that's not the criterion. The criterion is that the company as a whole will be in a better position after the action. This discretion is left with the court, and the court will not allow the action to be brought unless it satisfies a number of criteria that are set in the statute at the moment. Of course, the court will deny leave for an action to proceed if the breach of duty that we're talking about has been authorized or ratified by the company already. And it will also refuse to do it if somebody who is loyal to the company would see this as a waste of time and not a positive thing for the company to do. After it's dispensed with these things, that we're talking about a breach that has not been authorized, that has not been ratified, and somebody acting with loyalty to the company would want to see this through, then the court is going to ask itself whether the shareholder commencing the action is acting in good faith, whether they're acting in accordance with 172. You remember 172 section contains the duty to promote the success of the company, and whether it is brought for the benefit of the company as a whole and not only for the individual shareholder in question. We start off with these restrictive requirements as you find them in foss and harbottle, and we're replacing them with the statutory version that has the same level of judicial control over the action, but it now has a more streamlined set of factors to consider. The attempt of the legislator was to replace a very woolly test with a more specific test. The critique of this is that since the questions that we're asking are subjective, the test remains very woolly and you don't actually know what you're doing. Before, the test was you need to have discovered something really nasty to allow people to get on with it if this is going to be good for the company. Now you've got a test that says if somebody is acting in good faith and is acting in the interests of the company and they're likely to be defending like a legitimate problem, then fine, we should let it go on with it. One is not really fundamentally different from the other. Now, this has led to a series of cases where people are now battling to understand what the new test is about. I've given you the test in 260 from the 2006 Act, but modern versions of the derivative claims test were present in previous versions of the statute. That's why you got case law trying to interpret these new criteria going from. Well, you have, for instance, Wallersteiner versus Moyer from 1975. You got the case of Wishart versus Castlecroft Securities from 2009. And all of these cases are basically trying to do the same thing. They're trying to figure out whether the common law test has actually changed by a statutory one that in fact requires you to do something else. And whether a requirement such as good faith means something different now with the statutory test, and whether the inclusion of section 172 about acting in the interests of the company helps at all, or whether we are still in the situation that we were before. Of course, if somebody is successful, is granted leave by the court to pursue a derivative action, from that point onwards, the action becomes the company's and not the shareholders who brought it. And then any costs and so on are paid for by the company, not by the individual shareholder. If the individual shareholder is unsuccessful, then it stops, but whatever costs that they have incurred in bringing that litigation, then it falls on them. It is a risky thing for a shareholder. So this is not something that is done lightly, and it's certainly not something that is done in order to harass people unless the shareholder thinks that they've got a legitimate for success. You're going to use the derivative claims and the unfair prejudice in situations where somebody in a minority position feels that they're getting bullied, marginalized, harassed by the others. And the key question always, this is like the fork in the road that you got at the very beginning of this discussion, is where is the loss? If the harm is suffered by the company, then you need to talk about derivative actions. If the harm is suffered by an individual and only that particular individual, not the rest of the company, then you have to talk about unfair prejudice. And this is not the sort of situation that you can say, maybe it's that one and talk about one action, or it's the other one and talk about the other action. That doesn't save you either, because it shows that you're not capable of identifying whether the loss is the company's or the individual's. Coming across a discussion, some oppressed minority, and talking about both actions one after the other just demonstrates that you haven't really understood how they work. So for you to be able to answer questions that are set up like this, you need to have familiarity with the case of foss and harbottle, with the tests contained within foss and harbottle. It links up with the stuff that we have about the fundamentals of limited liability and separate corporate personality that you know about already. And then to be familiar with not only the test in the statute, that's easy, you can read the statute, but to be familiar with the interpretation of the test in the statute and some case law that has attempted to use it, so then you can have a legitimate debate as to whether things have improved or not. And what I'm thinking is the best way to do this is that if you remember some of the illustrative cases, like stuff that you see in here, you'll be able to find some cases that are in a manner with foss and harbottle, and the court is saying so, and you can use this as ammunition for an argument as nothing really has changed. Or you can find cases where the court says, look, now, using this test, we have a different outcome than we would have had if we had gone with the common law, so therefore now the statutory test, in fact offers an innovation in the way that this action is used. If we're trying to kind of close up a discussion about breaches of duty and what the directors are doing, so this is like a quick reminder of the general duties of the directors to the company, remember that. So they're obligated to stay within their powers, they're obligated to promote this of the company. When they're making decisions, they're obligated to exercise independent judgment. This covers the possibility that they're not actually making decisions when they should be. So this covers the nice situation that they've kind of subcontracting all decision making to somebody else, and then they're trying to dissociate themselves, which they shouldn't. When they are actually carrying out actions or making decisions, they need to exercise reasonable care, skill, and diligence. And then, of course, they're obligated to avoid conflicts of interests, not accept bribes, declare any interests. Now, 175 and 177, remember that the way in which you deal with the problem is to make the conflict go away through disclosure. And that's one of the key things that tends to escape people, because from the duties that you got all the way up till here, this is like the way you do it, and you're supposed to do it properly. Now you diverge from when you get to the conflicts of interest, because it doesn't it doesn't really matter what's happening anymore. What matters is, have you told the appropriate person about it, and have they told you it's okay to do it? It changes the nature of your behavior, it changes the nature of your actions. This doesn't. The actions will remain the same, but you made sure that you've disclosed and somebody said it's okay to go ahead. So don't forget the slightly different way in which the duties on the top differ from the conflict of interest provisions. The process is different. And even if, and this is an interesting one, even if you're not actually doing anything wrong, even if the company is not suffering any harm as a result of the action you're taking, if you have an unresolved conflict, the fact that it is unresolved, regardless of consequence, means that you're in breach. Now, I've been saying here that unless the company suffers some financial harm, then they're not going to sue you. So an unresolved conflict will be a breach. It puts you in breach of duty, but nobody's going to bring a derivative action unless the company has suffered damages. But there are other things that might happen to you. Some of these things have got criminal consequences, right? Remember that. So it could be that you're liable for a breach of duty. You're not paying particular attention because you don't think that the underlying action has caused any damage to the company, but it could be that you violated one of these things that unless you've disclosed, then you're committing a criminal offense. So you get yourself in trouble in different ways. And to wrap up the debate about what happens if you have breaches of duty, what happens is the company sues you, or you get in trouble with the authorities, or you commit some criminal offense, or you got civil consequences in terms of compensation. But there are also some administrative things that can happen to you. A section that talks about administrative remedies for breach of duty. These could be stuff like what you see in section 407, which contains the power to require information. The Secretary of State, which means the government authorities, could actually ask to investigate if they suspect that there's something wrong with the company. So they could ask for the provision of information. They could ask for additional documentation. This is over and above the annual returns that you make to Companies House. They could ask to come and see additional documentation to satisfy themselves that the company is running in an appropriate and legal way. They also have the power under Section 431 to appoint inspectors, and they can carry out a series of investigations. Now, this doesn't sound terrible. The whole point of using a corporate form is not only to take advantage of limited liability, but it's also to use perhaps some reputational effects and some reputational benefits of doing something through a recognized corporate form. If the authorities suspect that your company is mismanaged to the extent that they come to be requesting additional documentation and to be appointing inspectors and all of that stuff, then that gives a pretty bad message. Because if the authorities are aware of something, then probably all your customers and all your business partners are also aware that there's something going wrong. So company to that sort of trouble, and they're subject to administrative orders of this nature, they tend not to survive for very long. So this comes before the company has kind of hit the rocks, right? But it is certainly a secure evidence that there's something seriously wrong with this company.